We're just waiting for our one panelist to arrive, and then we'll get started.
Welcome, everybody. Thank you for joining us. Welcome to Holy Blossom Temple, to our members and to those joining from outside Toronto and other places. We're delighted you're with us, and we're very pleased to have been able to pull together this webinar on the question of the ICC's most recent decision to issue arrest warrants, to try to unpack that issue and understand what's behind it, and engage in conversation and questions about it. And we're delighted to have with us today two of our members. One of our members who's well known to us, John Allen, a member of our panel and organizing group for the Israel Dialogues. And many of you know John and know him well. John's a lawyer by profession, international law lawyer, having served in the Department of Foreign Affairs as a lawyer, and probably best known for having served as Canada's ambassador to Israel, and subsequent to that, before retirement, Canada's ambassador to Spain. So welcome to John. We also have with us Dr. Shai Manouchian, who is a member of Holy Blossom, and we're delighted to have him with us. Shai is an experienced tax executive and tax attorney specializing in U.S. international tax law. He's also spent a good deal of his time studying international law, doing graduate work in that area, and focusing on some of the issues that we're going to be discussing today. So with that, I'm delighted to welcome both of them. The approach will be, as always, we'll hear from both Shai and John. We'll each present, and then they'll engage in a bit of conversation together with myself and David DeWitt. And we will, as we move towards the 1 o'clock hour, address any of the questions that you may wish to raise with us, with the panelists. So please feel free to drop those into the Q&A, and we'll monitor that and raise those questions, and then we'll do a wrap-up, and we'll aim to end, as always, just before or at 1:30. With that, I'd like to turn it over to Shai for our first presentation. Shai?
Thank you very much, Mark, and thank you very much, David and John and Mark and Les, for hosting me on your panel. So I'll start with some of the background to the decision, because we're now in 2024, but really we need to go back to 1998 to understand what is the ICC, how it developed, how everything evolved from then, including the connection to the Israel-Palestinian conflict and how it is applied today. Before starting, just two comments that, something that I keep thinking whenever I read and look into this area. The first thing is something that my international law professor told me when I was at the LSE doing my PhD, is that international law, domestic law, is 90% law, 10% politics. International law, in contrast, is 90% politics, 10% law. So we need to take it into account when we talk about international law, because there's a lot of politics. And there's really no, even though the ICC is said to be, or aspires to be, something of that type, there's really no universal court that has sovereignty over all countries. And sometimes some countries disagree, and sometimes some countries decide to cooperate. So that's one thing. The second thing is that, I look a lot during my work, my daily work. I look a lot at biases and how people are affected by behavior psychology. And one of the most known biases is the confirmation bias or confirmatory bias. And there's no area like the Israel-Palestinian conflict to show how the confirmation bias is such a strong bias. It basically means that people have the tendency to search, interpret, and recall information in a way that confirms their prior or existing beliefs and values. And if there is one thing that you can see across the board when you read the different submissions, is that this bias is very strong on both sides. So with these two starting points, I'll delve into the issues. The ICC was basically set up in what is called now the Rome Statute in 1998. Israel was part of the countries that negotiated the Rome Statute, the Rome Treaty that then turned out to be the Rome Statute. But Israel, although it signed the treaty in 1998, withdrew from the treaty in 2002 and notified the ICC and the UN that it will not treat itself as coming under the jurisdiction of the ICC. The ICC was basically inspired by the horrible events of World War II and the ad hoc committees and courts that were set up since World War II to deal with horrific events and crimes against humanity and war crimes, including the court in Rwanda and the court in the former Yugoslavia. Similar to Israel, the US, and that's important when we'll talk about the future maybe later on in the dialogue, the US also signed the treaty. One of the last things that President Clinton did in his term was to sign the treaty. President Bush in 2002 withdrew from the treaty. The reason that Israel withdrew from the treaty was twofold. One, the treaty included among the definition of what constitutes a crime, the treaty included also a reference from the Fourth Geneva Convention on the movement of civilians into occupied territories. That was seen as a potential threat to the Israeli settlement in the West Bank in Gaza, and as a potential issue that can come up if Israel accept the jurisdiction of the International Criminal Court. The way that this crime was defined in the Rome Statute was wider than the way it is defined in the Geneva Convention, in a way that intentionally was tailor-made to address the Israeli settlement and was strongly supported by the Arab countries that put it forward and basically eventually caused it to be part of the statute. We'll come back to that when we talk in a second about the jurisdiction. The second reason that Israel decided eventually to withdraw is that it was concerned that the court and its institutions would be applied against it. And 20 years later, we are in roughly this situation, even though Israel is not a party to the court. There are currently 124 members. One member that is relevant for us is Palestine, which I'll talk in a few seconds. But before that, just to explain what does the treaty cover and what is the jurisdiction. In order for you to be subject to this jurisdiction of the court, you have to show, one, that the jurisdictions apply to you or to your acts, and two, that the acts are within the definition or potential definition of crimes as defined in the Statute of Rome. So for the first question, the jurisdiction, the person has to be either a citizen of a member state or to commit the acts in a jurisdiction of a member state. The person can also be a citizen of a non-member state that referred the matter to the ICC and delegated jurisdiction to the ICC on that matter or in general. A recent example is the case of Ukraine. Or the person commits the acts, the alleged crimes, in the jurisdiction, in the territory of that state or country that delegated jurisdiction to the ICC. Again, the recent example is the Ukraine with respect to the Russian invasion. The Ukraine is not a member of the ICC, but it delegated authority to the ICC, so the ICC can investigate and issue warrants and then start a case if they find sufficient evidence against the Russian activities in the territory of the Ukraine. There is another option, which is a reference by the UN Security Council, not to be confused by the US General Assembly. The Security Council is the only body that actually has enforcement rights in the UN, and that the Security Council can refer a case to the ICC and to grant by that jurisdiction to the ICC, even if the country or the territory in which the acts are taking place or the people who perform these acts have no connection to the ICC or to any of the member states. This happened more recently in the case of Sudan and Darfur. And it's something that, at least in other cases, did not take place because of a standstill in the Security Council between Russia on the one hand and the US on the other hand. If we have a jurisdiction, then we need to see whether we have a crime, and the crimes are defined in the Statute of Rome. They include crime against humanity, war crimes, and as I mentioned, also the transfer of population, the reason why Israel did not join the statute. In the case of Palestine, there is an interesting situation. Technically, Palestine is not recognized as a state, as a country. In order for a country, for a body to be recognized as a state, it has to satisfy 4 conditions under international law. These are conditions that were set forth back in 1933 in the Montevideo Treaty, and they include, among other things, there has to be a defined territory. There has to be government that can exercise control over that territory. They have to be able to enter into agreement with other parties, other states. And the big challenge with respect to the Palestinian Authority is their lack of defined territory, in some way due to their own acts, and the lack of their ability to exercise control over a said territory that is the requirement of a state. The Rome Statute specifically open its doors only to states to be members of the court. The Palestinian authorities tried in 2009 to become a member. The then prosecutor rejected its application. In 2012, and I didn't mention it until now, but today it's interesting that we have the discussion today, because today is a day with a lot of historic importance. It's the date of the UN resolution to pass the UN Declaration on the Two States back in 1947, the partition. And it's also the date, and that's why I mention it now, in which the UN General Assembly elevated the status of the Palestinian delegation to the UN from an observer to an observer state not member. Now, the way that the resolution was drafted is obviously very vague, and it's a looking forward statement to a future Palestinian states recognizing the right of the Palestinian people for self-determination and for a future independent state. The Palestinians used this and went back to the ICC in 2014 and requested to be accepted as a state. They followed the procedure, which is basically to deposit the necessary letter with the Secretary General in the UN, and they were accepted as a state. They were accepted as a member. Then came their follow-up to the then prosecutor, asking the prosecutor, now that Palestine is part of the court and has jurisdiction over Palestinian citizens, although it's not a state, and activities taking place in the territory of Palestine, even though it's not defined, to open an investigation. And an investigation started back in 2019. In 2020, the prosecutor asked to get the court approval for a full investigation. It is a requirement that when the investigation turns from a preliminary investigation to a full investigation, the court would approve it to the prosecutor if the prosecutor is the initiator, just to make sure that all initial jurisdictional issues are sorted out before an investigation begins. And in 2021, the court, in a majority of 2-1, approved the investigation to begin, the full investigation. The court did it in an ex parte process, which means it's not open to two sides. It's the prosecution asking the court, as the only party, to open a full investigation. The court accepted, before making the decision, briefs of friends of the court on this matter. The main two issues, or the main issue that was discussed then, was whether the court has jurisdiction in Palestine, in the occupied territories. The main arguments that were brought against this was, one, Palestine is not a state, and only states can be members of the court, and the fact that the procedural process was conducted in 2015 does not cure the fundamental flaw that Palestine is not a state and therefore cannot be party to the Rome Statute and therefore cannot grant jurisdiction. The most interesting part there was a submission by Professor Malcolm Shaw, a very known scholar in international law, that actually referred the prosecution and corrected them on their use of his treatise and their interpretation of his words. Apart from that, there was a very interesting submission by Professor Eyal Ben-Benishti, who is now a professor of international law at Cambridge, basically saying that the biggest issue is that there is no defined territory. And in the absence of defined territory, there cannot be a state. And there is no defined territory because the Palestinians throughout the years, and sometimes within a flip of a month, referred to their territory in a conflicting way. Sometimes they refer to 1947, sometimes they refer to 1949 after the Armistice Agreement, sometimes they refer to 1967, and it's hard to know what is the defined territory that they are referring to. Not to mention prior references like the reference in 1988 when they declared their independence in Algiers, where it's even vaguer, or to the founding documents of the PLO, the organization that later became the representative of the Palestinian people back in 1964. The court, as I said earlier, decided vote of 2-1 that there is jurisdiction, that this claim is not sufficient because the process was accepted. Why is this important? Because when the current prosecutor decided to issue arrest warrants, he had to overcome three thresholds. One, jurisdiction, and he applied to the court. The court in 2024 said this matter was already dealt with in 2021 and no need to revisit it. Done and dealt with. The second issue was that the crimes are within the list of crimes. One challenge is that the crime of starvation requires there to be an international conflict. Some of the crimes do not require an international conflict, so a country can be in a conflict with a non-country organization, and then that's sufficient. But in the case of starvation, there needs to be an international conflict, and the prosecutor argued, and the court accepted, that there is both an international and a non-international conflict. The third threshold is that there is admissibility. And admissibility means that that the crimes or the alleged crimes are of enough gravity to justify intervention, and two, that the relevant country, in our case Israel, has not done anything internally that would render the court redundant. And that's based on the principle that the court is not to replace the legal systems around the world, but to supplement. That's a fundamental theme of the court and its existence. And what happened was that in order for the court to assume jurisdiction, it has to show that Israel failed or doesn't have the mechanism or is unwilling to assume jurisdiction. Now, here comes something that was argued by Israel that we'll see how, the court initially dismissed it, we'll see what happens with it in the future. When the prosecution received the authority, the approval to start the investigation in 2021, there were three items that it announced to the court that it's looking into. One was the operation in 2014 in Gaza that's started, and the alleged acts that were conducted then by the IDF. The second was the events of 2018 and the walks of return to the Gaza border by Palestinians and the IDF reaction to that. And the third was the settlement and move of individuals into the West Bank from Israel since 2014. These three activities are fundamentally different from the activities that the current prosecutor issued a warrant for. And when in 2023, there were requests to the prosecution to start an investigation into the activities of Israel following its reaction to the October 7 attack, the prosecution said, we are going to include them as part of our ongoing investigation. One of the things that Israel is arguing is you should have given us notice in advance of a change in course. What you did back in 2021 is fundamentally different than what you're investigating now in 2024 and cannot come under the same umbrella and cannot get the protection that we were notified back in 2021, and therefore a new notification is not warranted. As I said, the court rejected this argument. The warrant were issued, and as a result, there are currently 2 arrest warrants against Netanyahu and Gallant. There is also an arrest warrant against Muhammad Deif, who is probably not with the living. And Israel, on 2 days ago, filed the notice of appeal, appealing the 2 decisions, one on the jurisdiction, the other one on the notice. I would like, before concluding and just mentioning some of my comments on the court, I would like just to, I don't know if the people on this call know, but in Israel, throughout these months, there is a parallel process in the Israeli Supreme Court. The Israeli Supreme Court, and the last hearing was on the 24th of November, is dealing with a petition of Gisha and other Israeli bodies that basically challenge the IDF activities and ask the Israeli Supreme Court, sitting as the High Court of Justice, to intervene and ensure that Israel is operating according to the international law obligations and does not use starvation as a method of war, or and basically act in accordance with international principles. For the last few months, there was a lot of back and forth in which the Israeli Defense Forces were required to provide documents to the Israeli court, some of them confidential, some of them were not, to show that it's providing enough food and other necessary goods into Gaza, and that it is fulfilling its obligations on international law. As at the latest hearing was on the 24th. I don't know yet what is the outcome and what is the follow-up, but we'll know soon. And throughout this process, the Israeli army provided information to show how they are supplying food and goods into and supplies into Gaza throughout the process. And there were questions by the judges who were challenging them. It was a very heated discussion. And that just one point, which I believe we'll get back to on the other requirements that the ICC has to show, which is that Israel is not doing sufficiently. 3 points on the ICC, and then I'll let John say his piece. Basically, my biggest concern with the ICC is that they need to make sure that they live to the body that they aspire to be. And especially in a case where we have so much, heated and emotion discussion from both sides, it has to show that it is doing what is necessary legally and not trying to hijack a case just because it's good for a discussion or good for the agenda of one or other party. The jurisdictional discussion should be much more thorough. The explanation, the justification, the analysis should be much more than what we saw so far. We're giving much more reference to arguments that were brought by both parties. This is missing. The second part that is missing is good faith. The fact that no new notice was given is a big flaw, in my view, to the prosecution. They should have given a notice, even if they think that technically they are not required to. A, because what happened in 2021 and what investigated in 2021 is substantially different than what we have in 2024. And B, because they need to show that they do everything in their power to serve justice, which means in both substantive and procedural fairness to all parties. And without giving Israel a new notice, Israel could not prepare on the complementarity argument, because back in 2014, Israel set up a unit in the IDF to investigate potential crimes that are committed by Israeli soldiers during war. This requirement satisfies any allegations against the IDF. It does not satisfy allegations against politicians. If Israel does not have a notice of what is coming, only when a warrant is requested, it cannot deal with it, especially not in a time of war. Now, Israel has a history of forming investigatory committee. It happened in the Yom Kippur War in 1973. It happened in the Lebanon War in 82, and in other occasions, non-war related. So there is a mechanism. We can talk about later on why it's not happening so far, but it still does not cure the fact that a notice should have been given. And the last thing is a better analysis should have been done with respect to jurisdiction. The analysis that is done, which is basically technicality, that the procedure was well in 2014, and therefore we don't need to revisit it. And then in 2024, referring to a decision that was done ex parte in 2021, again, as an excuse not to deal with something which is so fundamental to whether the ICC can actually have jurisdiction on this case, is something that I think should have been given much more consideration, and is still something that is causing some, doubt on the legitimacy of the ICC to deal with this specific matter.
Thank you, Shai, for that very comprehensive analysis. And you've raised a lot of things that we will obviously want to try to unpack even further. And I'd like now to turn it over to John Allen. John?
Thanks, Mark, and thanks, Shai and David and everybody. And before I start discussing the particular case of the ICC indictments and the request for the warrant, I wanted to preface my remarks by noting that I take no pleasure in arguing that the court may indeed be justified in moving to prosecute an Israeli prime minister and a former defense minister. Indeed, I think it's a very sad time, in my view, and a sad statement about where the current coalition in Israel is at and where it's taken the country. I also want to talk briefly about why I consider the court and its objectives so important. As Shai mentioned, the idea of the court came into being as a result of World War II, and more specifically, the Holocaust, as did many of the provisions of the Geneva Conventions that are intended to govern the conduct of leaders and combatants and the treatment of civilians, prisoners, and combatants in wartime. In part, those laws and the court were meant to address and deter and punish the worst of crimes, many of which are now prohibited under customary international law. Customary international law means that they don't even need a treaty to bind states and individuals. They're generally considered as crimes by the international community. And although not naive about what they could achieve, the founders of the court believed in the words "never again." And those words didn't mean and shouldn't mean just never again to the Jews, but they should mean never again to all mankind. Like Shai, I studied international law, and ironically, I also studied it at the LSE, but I only got a master's and he got a PhD, so I defer to him on many of the technical provisions. But I did study international human rights law, and I then practiced it at Foreign Affairs. And these were difficult times. The genocide in Rwanda, the atrocities in the Balkans and Sierra Leone, and others. I also headed our first delegation to the negotiations of the International Criminal Court, when the Americans were amongst the court's strongest supporters. They, like Israel, to some extent, dropped their support when it became too clear that the actions that they might take could bring them before the court. For the US, they had hoped that not only would the UN Security Council be able to initiate a prosecution, they also hoped that it would be able to veto one. In other words, if any action was brought against the US, they would be able to veto it. I'll come back to the US's inconsistent position on the court in a minute. So let's talk about the charges against Bibi and Gallant. I'm not going to go into the charges against Deif. They may well be dropped, and we know what those charges are. They're charges for the most horrible of crimes involved in the massacre of innocent women and children and men on October the 7th. I think those are fairly uncontroversial. But with respect to Bibi Netanyahu and Yoav Gallant, the judges found that there were reasonable grounds to believe that each has committed the war crime of using starvation as a method of warfare and crimes against humanity of murder, persecution, and other inhumane acts. They also found reasonable grounds to believe that they are each responsible for the war crime of intentionally directing attacks against civilians. Now, of course, these are charges, and if either ever appears before the court or appears before a court in Israel, those charges can be refuted and proved to be wrong. But I'd first like to dismiss the charges that we hear very often in the news, and we heard actually initially from both the US and Melanie Joly, the charges of moral equivalence that have been made. In examining the actions of individuals directing a war, the court does not measure which party committed the more serious crime and then choose the worst to prosecute. Individuals' actions are measured against the principles of international humanitarian law. In this case, both the Hamas militants and Bibi and Gallant are alleged to have breached international humanitarian law. Why did the prosecutor announce both sets of applications for arrest at the same time? Not because a 2-week siege is necessarily equivalent to the murder of innocent women and children, but because both are breaches of international humanitarian law, and because if he had announced either first and separately, the prosecutor would have been condemned for ignoring the other side. Second, Israel had options to avoid these charges. First, they didn't have to impose a siege for 2 weeks and then for over a year refuse to provide sufficient humanitarian assistance to 2.2 million Gazans. I reject completely the suggestions that more than enough food has entered the Strip. The US wasn't on the verge of sanctioning Israel 3 weeks ago because sufficient food, water, and medicines have been flowing into Gaza. Indeed, the US and all aid agencies in the Gaza Strip confirmed that Israel had met none of the US's benchmarks after that 30 days. The US and countries like Canada, the UK, and Germany are still demanding that more be done. The US didn't build a failed pier at the cost of $350 million because enough food was getting into Gaza. And Jordan and other countries weren't airdropping food because enough food was getting in either. And every NGO and international organization on the ground in Gaza is not lying when they describe surgeries without anesthetics, disease from unsafe water, and malnutrition amongst children. Yes, some shipments are being hijacked by criminal gangs and Hamas, but that's in part because there is no rule of law in Gaza. Israel has forced the disbanding of the police, and as both the occupying power and the military force on the ground, it has a specific obligation to allow the assistance in and then to ensure it reaches the population. Simply allowing an insufficient number of trucks into Gaza and then abandoning them as they enter the territory is not compliance with international humanitarian law. Third, had Israel followed the US's advice based on its own experiences in Iraq and Afghanistan and engaged in targeted killings of Hamas leaders, rather than dropping 5,000 and 2,000 pound bombs and more, Israel might have avoided the accusation of crimes against humanity for indiscriminate killing. Yes, Israel absolutely has and had the right to self-defense. No one denies it. The question being discussed, I think, by the court will be whether they fought a just war unjustly. We are all aware of how difficult it would be to fight in the narrow urban confines of Gaza. We have seen the tunnels and know that hostages have been hidden deep in them. I have not seen the evidence for the alleged crimes. It has not been made public. But given the massive death toll, upwards of 44,000, of which 2/3 could be innocent women and children and men, the over 100,000 injured, the widespread destruction, 60 to 70% of Gaza in rubble, and the continuing daily death reports, all justified by the alleged presence of Hamas militants hiding beneath the buildings being attacked, it doesn't surprise me that allegations of disproportionate killings have been made. Fourth, as Shai mentioned, the ICC operates under the principle of complementarity, which provides that if a state is willing and able to investigate and prosecute the alleged crimes, it can do so instead of the court. And this is what the ICC prosecutor had to say on this issue. Quote, in line with the Rome Statute, the door to complementarity continues to remain open. As with all situations, we will continue to actively assess the application of this fundamental principle, which requires genuine domestic investigations and any necessary prosecution of the same individuals for substantially the same conduct. So if Israel honestly and bona fides wants to begin investigations of Bibi and of Gallant, and they are serious about it, they can do so. In this case, however, Israel has refused to do so, just as it has refused, despite much Israeli precedent, to establish a state commission to investigate what happened on October 7 and thereafter. The fact that the current government has attempted to severely weaken and politicize the Supreme Court, the police, and the Office of the Attorney General, frequently threatening to fire her, likely did not help its case before the ICC. Ironically, Gallant himself warned Netanyahu that the attempted judicial coup, by destroying the independence of the Supreme Court, could expose Israeli officers to prosecution by the court. Equally important is the fact that both Gallant and his chief of staff stated publicly months ago that Israel has achieved its military objectives in Gaza and that so-called total victory is impossible. So if Israel's military objectives have largely been achieved, how does it justify the daily killings of innocent civilians? It's almost by definition disproportionate to its war aims. Michael Koplow of the International Policy Forum, Israel Policy Forum, has argued that because Bibi and Gallant likely will never appear before the court, such a prosecution exposes the court's impotence. That's quite an argument. I guess we should only try to arrest international criminals whom we are sure we can catch. Otherwise, you'll discredit the court. Frankly, neither international law nor international humanitarian law would exist if enforceability was the criterion. Do countries and individuals breach international law and sometimes evade condemnation or prosecution? Yes, more often than not. Will Vladimir Putin end up in The Hague? Not as long as he's Russia's czar. But Slobodan Milosevic never imagined he would end up before an international criminal tribunal, nor did the accused at Nuremberg, and nor did those prosecuted in tribunals for crimes committed in Sierra Leone or in Cambodia. Moreover, Putin has now been forced to avoid both a BRICS meeting in South Africa and the G20 in Brazil. What happens after he steps down, if he ever does, is not clear. By the way, regarding Putin's indictment, the US government that called the court outrageous for these proceedings praised the court when Putin was indicted and ordered US intelligence agencies to provide that court with all available evidence against Putin. Trust and confidence in an institution and in its prosecutor seems to be inconsistently proffered depending on whether the defendant is friend or foe. But going back to Koplow's argument, even if only a few international criminals serve sentences, this is no reason to abandon international humanitarian law or the ICC. How many violations have they prevented because of the possible consequences? How many prisoners have avoided being tortured because of international humanitarian law? How many soldiers' lives have been saved because chemical weapons are prohibited? And how many citizens are alive because of the laws prohibiting disproportionate killings? Not enough, I would argue, but hopefully enough to ensure that international humanitarian law is supported by all states who believe in human rights and the rule of law. Another point raised by Koplow needs to be challenged. He questions whether a democratically elected leader should be issued a warrant. International law decisions aren't based, nor should they be, on whether the person charged is freely elected or not. Adolf Hitler was democratically elected. So was Milosevic. Augusto Pinochet was democratically elected years after his coup. Should being elected shield anyone if they subsequently commit war crimes? I think not. Finally, Koplow suggests that the warrants for Bibi and Gallant will sour Israel's and Israelis' relationship with the United Nations. This is the country that declared the UN Secretary General persona non grata and that declared UNRWA a terrorist organization. The same country that allegedly fired on and killed UNIFIL observers in Lebanon, both in the 2006 war, including a Canadian soldier, and in the recent war. I'm not sure Michael has listened to the way the Israeli ambassador at the UN disparages the organization, labeling it both anti-Israel and, of course, anti-Semitic, or the way Benjamin Netanyahu did the same when he spoke before the UN and before Congress. Arrest warrants for Netanyahu and Gallant certainly won't help that relationship, but I highly doubt there is much left to resuscitate anyway. Frankly, I doubt that Israel would ever allow a UN force to do what Koplow describes in terms of reconstruction and bringing the rule of law back to Gaza. There will have to be a coalition of forces, perhaps supported by a UN Security Council mandate, but not a UN force. Then we have Canada's former finance minister, Joe Oliver, in the National Post, claiming that the charges are false and that they are a biased prosecution of the Jewish state. He claims that the ICC warrants are similar to the Dreyfus case. That case, the Dreyfus case, was based, as you know, on lies. Here, 6 prominent jurists, including Ted Meron, a former Israeli Ministry of Foreign Affairs legal advisor, reviewed the arrest warrants before they were submitted to the judges and all agreed that there was sufficient evidence to justify them. 3 independent judges, led by an experienced French judge, also agreed that there were reasonable grounds to believe that the crimes have been committed. If they ever end up in The Hague, or if Israel ever chooses to prosecute, as I said, both Bibi and Gallant may well be able to disprove these allegations, but this is not the Dreyfus case revisited. Oliver asks, and so have others, why isn't Bashar al-Assad being prosecuted? This is classic whataboutism, i.e., let's ignore the siege or the settlements or the occupation because Syria or Iran or China have done and are doing much worse. These are not serious arguments. Assad was not prosecuted, A, because Syria is not party to the statute, and B, because he committed his horrific crimes on his own citizens within his own territory. The court does not have jurisdiction in such cases. And if the court did try to go after him, critics would, as some are now, be screaming judicial overreach. Finally, on the question of the court's jurisdiction, that was argued and decided, as Shai said years ago. Israel knew very well that Palestine was a party to the ICC. Moreover, as Shai mentioned, international law in some respects is 90% politics and 10% law. When it comes to recognition of states, it's 100% politics and no law. There are criteria, but states do not have to follow that criteria in recognizing a state. 149 countries have recognized Palestine, including Spain, Ireland, Belgium, and a number of other EU members. Canada is currently considering recognizing Palestine, as is Australia, New Zealand, the UK, and others. Many court decisions are not unanimous. We just have to look at the US Supreme Court. So perhaps the ICC wasn't unanimous in deciding that Palestine could be a state party to the ICC, but it has been decided. So I think I will stop there, and I'm more than happy to take your questions, and I look forward to them. Thanks very much.
Can I comment on a couple
Yes,
things?
yes. Thank you, John. Again, another very important analysis, and really appreciate your perspective, your overview, and bringing to light all of the points you did. Let me go to Shai first, who I think would like to respond to your comments and perhaps add some others. Go ahead, Shai.
Thank you. So a couple of things, and David, yes, sir. John, thank you very much for the very interesting overview and for touching upon points that I did not touch. So we have a very comprehensive review altogether. I will not go into the facts just because we don't know the facts, unfortunately. I would just like to say a few things. One is that there are other organizations, including West Point and John Spencer in particular, that been to the Gaza Strip and came up with different analysis on the way that Israel is conducting the war. This specific individual is the U.S. expert on urban warfare. And, you know, we need to recognize that the facts are, unfortunately, as in many cases, very much in dispute. And that's for a committee or some sort of organization when the time comes to review it. The second point is regarding the starvation. There is a lot of talk about Israel and the siege and everything. Often neglected, important to remember, there is another entry into Gaza from Egypt, blocked intentionally, open only to smugglers who smuggled a lot of very poor, very unfortunate Gazan families for a very high price. So there is a very clear point into Gaza through Egypt. Egypt did not want to deal with it. And then just going back to the jurisdiction and to the situation of the case, we still don't have a case. We just have warrants. We don't know how much time it will take until the prosecutor decides to actually file the case. So we are still in the pre-case phase, and that's important just to clarify. That's something that I didn't do. I just want to clarify it. The second thing on the jurisdiction, I would have respected the ICC had they said 140 countries, although most recently more countries, recognize Palestine as a state and therefore recognition. International law puts recognition as an important element, but not as a cure or a full cure for the four elements. And that's something that Professor Malcolm Shaw is addressing to the ICC in his 2020 amicus brief. I would have respected that had the ICC said, we recognize, or Palestine is recognized as a state, and therefore it's party to the treaty. But that's not what they did. They tried to come with an argument that it is a state for the purpose of this treaty, but not a state for all general purposes. And this is something that international law does not recognize. You either are a state or you're not a state. The Statute of Rome does not distinguish between states and others not as a state who may be equivalent to a state. And then what they did was to turn it around and say it would be not in good faith to interpret the statute to impose additional requirements on Palestine once the Secretary General accepted it. There is a 2015 letter by a former guest of this panel, Ambassador Baker. He wrote to the Secretary General of the UN at the time, and he said, what you did was abuse of your office when you accepted and deposited the letter from Mahmoud Abbas to the ICC asking for accession. That's why I think that this is a fundamental question that deserves a fundamental and in-depth analysis. Don't escape the question. Either you recognize Palestine as a state, and then it's from the day of recognition, not from 2014, and you apply the statute to them, or it's not a state. Arguing that in 2021 that we followed the process, and therefore, if the process is well, the substantive elements are also good, that's avoiding the issue. And then coming back in 2024 and referring to this flawed analysis as the basis for your decision is putting one flawed analysis on top of another flawed analysis. There has to be a discussion, a true discussion into jurisdiction for the sake of the court. Because if the court wants to be respected, it has to act to deserve the respect. And I really hope that the ICC would be up to this challenge, because the ICC was set up for very important reasons, and you alluded to them, John, in your talk. They need to be very clear on the issue of jurisdiction for the same reason that they don't go after Bashar al-Assad in Syria, for the same reason they don't go after Erdogan in Turkey. For all these reasons, because these countries are not members of the Treaty of Rome. They're not subject to the jurisdiction of the ICC, and the Security Council did not remit their case. And that's where I think that there is a major flaw in the technicality of the analysis of the ICC, and in this case. And I really hope that they step up their game, because they're not doing so. They're not doing so also on the notice that they haven't filed to Israel when the case substantially changed, because the IDF is investigating its activities, and they haven't done so when you hear that the prosecutor is now subject to a sexual harassment charges that are being investigated externally. He should set himself aside and let other person take the position. I don't think there will be a different course in the way that the prosecuting is handling itself, but at least it look much better from the clean hand perspective that the prosecutor is above reproach. And the last point on the committee did not disclose any documents, and one member of the committee that you referred to, Justice Meron, he's not in very good terms with Israel and its foreign office. He left the foreign office with a very bad taste after the foreign office refused to grant his spouse a diplomatic status. That didn't end well. And he would be the last person I would choose to sit on a panel if you want a panel of objective people.
Thank you. John, you want to respond before we go into some questions from David and myself?
Yeah,
And
just
before you speak, John, just remind the participants that if they do have questions, to please drop them into the Q&A. Please, John, go ahead.
yeah. Look, on the jurisdiction, Shai, Israel's appealed, and I like you hope that the appeal is heard, is treated objectively, and is dealt with. And I hope that if the case ever does go forward, that the ICC will approach it in an unbiased and objective way. On Ted Meron, by the way, the other reason that he didn't leave the foreign ministry in such good stead is because he ruled that building settlements in the territories was contrary to international law. And apparently the government didn't like it because the government of the day proceeded to build its first settlements after 1967. And I think that might have had more to do with the relationship between Ted Meron and Israel than the other, but you could be right on that. John Spencer is brought up by everybody who claims that that Israel has not been disproportionate in its activities. Indeed, he's the only person that I have ever seen who has made that argument, and he's on every Zoom that wants to demonstrate that Israel is acting proportionately and that the number of deaths compared to the number of innocent deaths compared to the bombs dropped, etc., is less than what the United States did in World War II, etc. I've never heard another so-called expert, and he is an expert, make these same claims. And I would just say that I was recently reading about the IDF unit that has been set up to investigate claims of soldiers' activities in the West Bank. And my understanding, based on what I read, is that of the 800 people that were investigated, the 800 soldiers that have been investigated between 2020 and 2024, one has been indicted. Many more have been investigated, but actually one has been not indicted, but convicted of a wrongdoing. And I think that, what's been happening in the West Bank vis-a-vis settler violence against Palestinians, with the IDF watching what happened when settlers basically stormed a prison trying to release people that were accused of sexual violence against a Palestinian prisoner. I mean, I just don't think that so far the IDF has demonstrated that it's necessarily up to the job of dealing with soldiers, a number of whom are definitely committing crimes individual soldiers that are committing crimes in Gaza. There are individual testimonies of many soldiers who have seen destruction of homes, killings, abuse of prisoners in Gaza, and there may be investigations, and I hope they do result in objective decisions. But I'm not sure that Israel's yet demonstrated a complete objectivity in that regard.
Can I just quickly answer on this? Two things. One, the war is still ongoing. I agree with you on the instances in the West Bank. They are disturbing. The instance in Sde Teman is extremely disturbing. I think, and I hope to be proven right, that it's just a matter of time. They are swamped. They are in the middle of the war. They are also advising, right? The same unit also advises, different part of the unit, the IDF of how to conduct the war within international laws. So you can expect some delay. A reference on the complementarity, can never get this wrong, right? Principle. When an investigation was launched against the UK its Iraq operation, the UK managed to basically end the investigation by showing complementarity, by showing that it investigated soldier for alleged crime. In that instance, none of the soldiers was convicted, and it was still sufficient. I think that if you give the IDF sufficient time, they'll get there. There is a lot of pressure. It's still the middle of the war, and that has to be taken into account. And I completely agree with you in some of the instances in the West Bank that, unfortunately, when the attention is elsewhere, are being used to take this out.
I agree. Thanks. Thanks very much.
Thank you. Shai, just on that last point, I assume, I think, can we take it that the IDF is keeping copious records and notes of all of these instances, so that when the dust settles, they'll be able to move forward on some of these allegations and charges against various IDF soldiers?
I hope so. That's at least one of the recommendations that followed a previous event. I don't remember, it's the 2006 or in Lebanon or the 2014 in Gaza or both. But the IDF is JAG forces very much both in the offensive side in advising how to conduct the war, but also on the investigations. The army, according to what the chief of staff is publishing, is also conducting its own review of the event that led to October 7. So there is a lot of work that has to be done by roughly the same people. I guess it will just take time for them to do that.
Okay, before I turn it over to David, I have something that's been sort of nagging at me for years, and I've wanted to raise it, and it sort of dovetails with what we're talking about in terms of the recognition of Palestine as a state. Many states or countries have been recognized and become members of the UN since the late 50s, early 60s. And they each time, if I'm correct, have declared themselves as a state, applied for membership to the UN, gone through the process and been accepted as a state member of the United Nations. What I'm wondering is, what's prevented Palestine, Abu Mazen and the Palestinian Authority from declaring themselves a state, and why that hasn't taken place over all the years that we've been dealing with this conflict?
Well, I think, if I'm not mistaken, and Shai, you can correct me, it requires UN Security Council approval, and the United States has indicated that it will veto Palestine's request until ...
That's not what I'm asking. That's for application to the UN, right? That's for admission
Yes.
to the UN. I'm talking about just declaring themselves as a state and
Oh, they
having,
did it in 1988.
yeah, but
In Algeria, years before the Oslo Accord, they unilaterally declared themselves as a state. And for those who are interested in history, there is a reason why they did it in Algeria, of all places.
okay, thank you. David. Yeah. David?
Yeah.
You're good.
Sorry, I've got this in. There's a message in the middle of my screen. Okay. Thank you both. I'm really not sure where to begin on this. I guess I have to offer my bias first. My bias is that I guess I'm an old-fashioned liberal internationalist who believes very strongly that ultimately the intent behind the creation and strengthening of international institutions is fundamentally the benefit of all of us, regardless of where we fit in state development and wealth and power. And yet we also know, and you both have said it much more eloquently, one of the fundamental challenges in international law is the question of enforcement. And we know the difference between law domestically and law internationally and how that works. So I think I have less of a question and more of a comment that is probably going to be controversial that you may or may not wish to respond to. In a curious way, I see this issuing of warrants in this debate as long overdue. It's long overdue because I'm hoping that it brings serious attention within the Israeli polity to the whole question of the legality of settlements and the political implications of not addressing them. Seems to me that from point of view, if I were sitting in the ICC and I would look at the question of complementarity and I would look at the record of either the political interference or the unwillingness of established institutions in Israel to address the encroachment of settlements and the violence, whether it's provoked or otherwise, and not having addressed those in a systematic and sustained way as highly problematic and undermining my assurance that complementarity is actually a possibility. I have great admiration for the sitting Attorney General in Israel, who has stood up to enormous amount of domestic political pressure. And it seems to me that she and her colleagues have been quite remarkable in trying to reassert the rule of law within Israel, although with very questionable success. So where does that leave the current conundrum that Shai and John have addressed so eloquently? I do see the value of the ICC. I do understand and appreciate the politicization of it and how internationally it's 90% politics. I'll throw out there that I'm not sure that in this climate that is necessarily a bad thing if it brings a range of not only new awareness, but a range of pressures on trying to do a number of things. One, it would be useful, I think, to the Israeli people and to others to have a clear articulation of what, in fact, the strategic goals of the elected Israeli government actually are. If the recent Knesset vote is one that expresses the long-term view of the notion of annexation settlement, then at least we know where things stand. If that's a misreading of it, or if that's part of the politicization of what's going on, then it needs to be addressed. It's not clear what is meant by the continuation of the bombing in Gaza. John's point about targeted assassinations and more clinical strikes, we know that was a strong debate early on in the current violence following October 7th. And the Americans, while they argued that was important, also argued that their experiences in Iraq and Afghanistan suggested that more would be needed, that alone would be insufficient. And as the tunnels became uncovered, the degree and the severity of and the significance of the Hamas capabilities, one can understand that there were military incentives to go in and try and deal with those. And one can understand that there would be civilian casualties because of the embeddedness of Hamas within the civilians. But it never became clear, at least not to me, what was the threshold that would lead to the Israeli government determining when, in fact, they had achieved sufficient damage that they could turn to other aspects, primarily the humanitarian aid, primarily recognizing that it's not just opening the borders and getting the aid in, but you have a responsibility as the occupying power to secure that aid and to secure the distribution of that aid and to protect the civilians, as difficult as we know that must have been. So, as I said, I don't have a question because I believe in the international institution and I can see how difficult the situation is. I do have a reflection that says this controversy and these debates about the ICC perhaps will bring some pressure on the Israeli political system that they will address some of the concerns that are now being raised internationally. That may be pie in the sky naivete. I don't think, however, from what I understand and from what you both have so articulately presented, that the ICC is wrong in having moved forward. What I am very unsure about is the credibility and the veracity of the evidence. Now, John has referred that there is considerable evidence on the humanitarian side. And I think that is probably correct. Um, there has been a strong response by Israelis to challenge that. Again, the evidence or the facts are not clear to me. And until we see those, we're kind of in a point of debate rather than being able to make confirmatory decisions.
Thank you.
Shai, I see your hand.
Yeah, so before I go to Shai, I just want to say, David, in response to the ICC warrants may be bringing some pressure to bear on the Israeli political environment. I think we should note that members of the opposition parties, Gantz included, have already expressed themselves in opposition to the warrants and taking issue with them. So it's still not clear to me whether there's a sort of division or clear view about that.
I agree. And as you'll recall, I sent in a note back to John that I thought it was potentially politically unfortunate because the ICC would in fact embolden not just the right, but likely bring a lot of people in the center, even the center left, over to the right in support of a defense of the Israeli government. So I agree it's unfortunate.
Yeah, that may be
happening. That there are unintended consequences.
Right. Let me go to Shai quickly, and then we do have a couple of questions, and then we'll wrap it up. Shai?
So a couple of points. One, I think that the warrants were premature just because they should have exhausted better the jurisdiction before issuing a warrant. I mean, Netanyahu is not going anywhere. He's not planning to go anywhere. And the warrant could have been issued later on, hopefully on a better basis. And now they have a second bite at the apple, and hopefully the appellate division will deal with it to the merit. Second thing is the Palestinians have been launching a lawfare, and that's part of the lawfare for the last 20 years. The problem of international institutions when they are in the form of a court are that they are adversarial. Instead, and then I'm speaking as a lawyer for 30 years, instead of helping to cure the conflict, they exaggerate it. They make it bigger. They put you in two sides. And I think that there is here a risk of two things. One, Netanyahu will be much stronger. And Mark, you alluded to that earlier. And we already see that his coalition is 68 now, not 64. 67 if Gallant is not counted. So that's one thing. The second thing is that if Israel is under attack and the question of jurisdiction and all other things are dubious, that all plays to Netanyahu and make it much harder for the center in Israel to stand up and challenge him. And while all of that is happening, things are happening as well, like slowly changing the judicial system in light of the plan that was originally introduced 2 years ago. I mean, it's hard to imagine that so much time has passed, but back in January 2023, there was a plan that was introduced. It never stopped. It was never rejected. It's still ongoing. We still see it. If you want to have investigation committee, formal state level investigation committee, the difference between that and a governmental investigative committee is one thing: the person who appoints the members of the committee. Because if it's a state committee, it's the Chief Justice of the Supreme Court. And if it's a governmental, it's the government. And if we want to have an effective body, we need to have the former, not the latter. And that's what the majority of the people in Israel, including those who support Netanyahu, want. The thing is that at the moment, there is only an active Chief Justice. There's no Chief Justice because the Chief Justice retired. The active Chief Justice that replaced her retired. And now we have another one because the committee to appoint new justices is not being convened. So, it all ends up together, and unfortunately, the ICC, instead of helping in the process, is indirectly, in my view, also hindering what's going on internally.
So I'd like to respond because we have now moved into pure politics.
Yeah.
And this is exactly where we should not be. I agree with all of you that, this isn't going to move the Israeli polity in any way. And it'll probably make them hate the UN all the more. But this is totally irrelevant to what is happening. The ICC and its prosecutor should not be looking into the state of Israeli politics and deciding whether or not its credibility is going to be heightened or not by whether or not the government or its citizens who hate the UN from day one are going to move farther to the right. It's totally and completely ridiculous. Yes, I mean, the ICC was criticized for years because it only went after Africans. Now that they're not going after only Africans, they're being criticized because they're going after democracies. It's, this is not about internal politics. And as we've said before, if only Israel would appoint a state commission, as Shai has suggested. I mean, let's realize Yoav Gallant was fired for 3 reasons. One, because Bibi wouldn't appoint a state commission to investigate Gallant and Bibi and everybody else. He was also fired because he wouldn't do a deal on hostages, which meant that he agreed that the military objectives had been achieved and they could do a deal on hostages and have a ceasefire and end the war. Okay, so let's just see what's going on here. I want to just also say this business about 90% of politics and 10%, that does not apply to the International Criminal Court. It doesn't apply to international humanitarian law. Okay, I don't think to international law more generally, perhaps, and 90% is too strong a word. The enforcement of domestic law. How many criminals are never prosecuted? How many criminals commit crimes in Canada and never appear before a court? Or, so I don't think we should take that too far. But it is unfortunate that the ICC decision will move Israelis. But what they might do, David, is actually force a state commission. What they might do is wake Israelis up to the fact that they better do it themselves, or this can happen again. The other thing I want to say is about lawfare. The Palestinians are, what is their option? Okay, it's not supposed to be violence. It's not supposed to be BDS. So what did they do? They took to the courts to try and get their rights enforced. And if going to the courts in order to declare settlements illegal and the occupation illegal is what they have to do, then as far as I'm concerned, lawfare or using the international law for its legitimate purposes is what they should be doing. You can't tell them you can't do this and you can't do that. So just sit there and continue to be occupied and have the settlements increase.
All right, Shai, you want to make a comment, and then I do want to try to get one question in before we end. There are a number of questions in, and I apologize to those whose questions we're not going to be able to address, but there is one question I do want to raise. Shai, and then one question.
Thank you. So just on the lawfare is not the lawfare. It depends on how you look at what the Palestinians is trying to achieve. What I think, in my view, the Palestinians are trying to achieve is to isolate Israel and treat it as an isolated, not to be touched state through lawfare. They do it because they realized early in the 2000s that the forums like the US or Europe are not good forums for them to bring claims. there was a lot of litigation in the U.S. around financing of terrorism that went against them. And then they decided to pick forums that are better for them, ICJ and ICC. That's why you have all the move towards the ICC to become a member. And it's not for them to actually get Netanyahu convicted. Whether Netanyahu is convicted or not is immaterial. The fact that Netanyahu currently is under an arrest warrant, they tick the box. It's done. They're not looking for justice. They're looking to isolate Israel, and there's a difference. There's a difference of how you use the law to achieve a different purpose. I'm not saying legitimate, I'm not judging, I'm just observing. And there is a difference when you do that. The same thing with the ICJ in the genocide case. There's no genocide, but they bring a case because they want to tie the Israel name to the genocide. The former Chief Justice of the ICJ, who retired after the first hearing, said exactly what they meant by plausible case, that there is a plausible right of the Palestinians, not that there is a plausible case of genocide. But it doesn't matter, because as far as they're concerned, the goal was achieved. The Israel name is now tied to the genocide. It will be tied forever. You know, this is what I talk about law for. The objective is to isolate Israel, whether it's to leverage it to a better deal on the territories, whether for other means. It doesn't matter. That's what he's been doing. And unfortunately, these institutions are being used for this purpose, which is different than the purpose they were set up for. Now, if the ICC would discuss the question of jurisdiction in depth, that would be a different matter. But issuing a warrant without dealing with the question of whether you have a jurisdiction to begin with and saying to Israel it's premature, bring it at a later stage, that in a way allowing the law to persist. And that's why a lot of Israelis question the legitimacy of the ICC. If you want to be seen as impartial, it's not going to help that you write that you're impartial. It would help if you act as impartial.
Thank you. Let me just try to get this one question in, and that's, it was directed, one of our participants asked if we could comment a little bit more on the Canadian and US response to the warrants and what may happen going forward. John, then maybe Shai.
Well, I think we kind of talked about it already. The Canada, who's a party to the statute, has essentially said that it's going to abide by the rules of the statute, and the rules of the statute require it to arrest somebody for whom there's a warrant. And I assume that Bibi will not come to Canada. Frankly, I doubt that he's going to go to France either, because that was a pretty wishy-washy statement by the French, who allegedly did it because they wanted to be included in the Lebanon ceasefire deal. But whatever reason, it doesn't matter. Talking about the credibility of the court, what is key to the credibility of the court is that the state parties to the court, abide by their obligations. That's what's key. So as far as the United States is concerned, again, I said what I said. They were very happy with the court when Putin was indicted. They praised it. The prosecutor was clearly objective. The court was objective. But all of a sudden, because it's Israel, it's no longer, it's an outrageous decision, moral ambiguity, moral equivalence. They are, well, I don't know if the Biden administration would have imposed sanctions, but the Trump administration is saying, and I have no reason to believe that they won't do it, they're going to impose sanctions on the prosecutor, on the other members of the bureaucracy in the ICC, maybe on the judges and their families, and who knows what else. They can't cut off financial support to the ICC because they don't pay. So, but they may well go after other elements in the United Nations in order to punish the ICC, which I find totally reprehensible.
Shai, did you want to make one final comment before I?
Yes, just to add to what John just said, two things. One, the Trump administration already imposed sanction on the previous prosecutor when she was looking towards Afghanistan. So there's no reason to think that it's not going to do the same thing. Actually, the new security advisor, national security advisor, is using the same tone that was used back by the Bush administration in 2002. So that's one thing. The second thing is that they have the Invasion of Hague Act in the US that allows the president basically almost unlimited authority when it comes to save and protect US service persons and members of allies against prosecution in The Hague. It was adopted in 2002, I believe, by the Bush administration, and it's still in force. So Trump also has the ability, not just the wish if he wants. My guess, he's going to leverage it against Bibi to get him into a deal of the century. I would not overlook this option. Now he has a very good leverage to bring Bibi to the table to a deal that he wants. And if he can broker the deal from the other end, going back to politics, I would not be surprised to see the US acting in that fashion.
Thank you very much to both of you, to David, and to the participants who have been with us throughout. And sorry we've gone over a little past the hour, but I think it's been very important to do so. I think this has been a very enlightening and important session. I'm glad we were able to do it. It's been recorded, so when the recording comes out, please share it with others who didn't have an opportunity to be with us during the live session. And I want to thank you all for being with us. And we have another session coming up next week, and I hope that you'll all be with us. Then David DeWitt will be moderating that session, and it will be hopefully as interesting and as informative as today's session. I want to wish all of you a Shabbat Shalom, and looking forward to seeing you next week. Thank you.
Thanks all.
Thank you. Terrific session, John and Shai. Thank you.
Thank you.